Right, good afternoon, everyone, and welcome to this week's Tea and Tech, our weekly discussion panel looking at what's happening in tech law and the wider world. I'm David Chaplin, editor of Computers Law, and this week, in a change to the advertised lineup, I'm delighted to be joined by Dr. Kuan Hong, director in the Privacy, Security and Information Law team at Field Fisher, and Ashley Winton, global director, Protection and Privacy, Information and Governance and Cybersecurity Compliance at McDermott, Will and Emery. Of course, while we are talking, the chat panel is open for you to chip in with any comments you might have to help the conversation along. So, with that said, there was one other thing I wanted to mention we published last week before I introduce Kuan, which is Kuan has put together a really useful infographic about the Digital Services Act that it gives you a really good visual way of getting to the key parts of the Digital Services Act. And so take a look at that as well. It's all on the site. So, with that, I will introduce Kuan, who is, we've just had the EU's decision, adequacy decision, sorry, I'll get that out. And it's good news for us. And you've been having a look at it. So can you please explain briefly what they've said?
Indeed. Thank you, David. Obviously, this all started with the FT on Monday saying, we've seen a draft decision going to be approved this week. And then the Independent had a video of a commission official saying, we are going to start the process. And then today, the commission has said, we are starting the process. They have issued draft decisions, but we're not at the end of the process yet. That's the main thing to emphasize. If I take you back a little bit, this is the Brexit timeline, or what I call nick of timeline, because the trade and cooperation agreement between the UK and EU was literally agreed pretty much at the last minute and towards the end of December. But this does provide for a bridging period. So we have until the end of April, and then unless the UK or EU objects, then we have until the end of June. And during this bridging period, all the flows from the EU to the UK are permitted. However, after that, unless we get an adequacy decision, who knows? So the whole point of this bridging period was to allow for an adequacy decision. I don't think it's necessarily done and dusted completely yet, because to approve an adequacy decision, it's not enough to publish the draft as the Commission has done today. It has to go through what's known as the comitology process. So this is a flowchart I did a while back showing this committee process where basically the Council has to approve, so the EU member states have got to vote and approve it. The EDPB, the European Data Protection Board, is also supposed to give an opinion on the draft decision. This is not binding, but from past experience with the first GDPR adequacy decision, which was for Japan, it does look like it is taken into account. For Japan, they've modified the draft to take account of comments by the EDPB, by the European Parliament before it was finally approved. So taking that as a comparator, for Japan, it took about 4 months from this first committee meeting till its approval. So we will see what happens here, but the Japan decision was about 60 pages long, and this is nearly 90 pages. This is probably the longest adequacy decision so far, and I guess that's because it's known that there will be quite a lot of objections to it, so maybe they're trying to forestall it. There's quite a lot on, intelligence services processing and so on. Obviously, I haven't read the whole thing yet, just done a quick skim.
It's impressive that you've got that far, Kuan, with the time since we've had it. It is unbelievably thick, and by comparison with the Japanese adequacy, Japanese privacy law is nothing like European privacy law at all. And so, in the detail of that, they actually developed a supplement, an annex of additional rules that had to be put in place. Fortunately, no such annex here. But it's weird, isn't it, that a much more complicated mapping between European and Japanese law is done relatively simply. And this, which should be virtually automatic, is much more complicated. I think we'll end up getting stuck on some really fine points that are, in my view, completely out of proportion with the way that adequacy works generally.
I think a lot of it, of course, as everybody knows, is very political. So not so much is it adequate, but there's a lot of politics there, I think, which is going to be one of the difficult issues going forward.
If we fail to get adequacy, and I actually just say, I think it would be, I strongly welcome this. It's great for businesses. This is a great thing that we've got this. But if this fails, must logically, you need to put the other adequacy decisions into focus because we have adequacy with countries that barely have functioning data protection authorities, never mind compatible laws. And so it will be a nonsense if this fails without a thorough review of each of the other adequacy decisions that are in play.
Yes.
They've got to be consistent, haven't they, across all of these decisions?
Yeah.
Does
I mean,
either
the
one of you?
commission, sorry, the commission is reviewing. I think I saw somewhere that they were going to be publishing their reviews of the other adequacy decisions fairly soon, within the next few months. But even if this one fails, the clever thing is that in the trade and cooperation agreement, if I go back to that, there are provisions regarding the partnership council between the EU and the UK. And this partnership council does have power to amend the agreement, to supplement it, to make recommendations about transfers. So it's like they've put in place a kind of a fail-safe, or a way to, if it all goes horribly wrong, to do something that will extend it further.
Oh, I see. Okay, that sounds great. Yes.
And if it does get struck down by the court, then unlike with the Privacy Shield, having the Partnership Council provides a way to quickly put something else in place much faster than is happening now post Privacy Shield.
Do you have any favourite bits in here that you'll look for when you come to look at it through in detail?
No. I mean, I haven't looked at it in that much detail yet. Have you?
I've got two I'm looking to look for, let me tell you.
Okay.
And I don't know if they're in here. We'll see.
Uh-huh.
The first is, of course, you'll recall that under the Withdrawal Act, existing European data in the UK would need to be kept to GDPR standards. And it was Article 71. So I want to see if that's referenced. That would be quite interesting. And the second bit, which is my absolute favourite, is onward transfer. Because we know through some of those leaked papers for the UK-US transfer that the UK was perhaps considering a more relaxed scheme for allowing data transfer from the UK to the US. And so I really want to see what they say in here. I don't know if the ICO still has on its website that rather peculiar statement that was up there a few months ago, saying that, oh, well, if the receiving entity is subject to the GDPR, you could export at will type statement, which was clearly wrong. But they, even their challenge, they kept up there.
Well, a few comments that I think the first point about the legacy personal data, that requirement is supposed to fall away if we get an adequacy decision. So it's only unless and until we get the adequacy decision. But if it doesn't fall away, then yes, we might be stuck with that sort of third track, frozen GDPR as regards non-UK personal data collected before 31st December. Onward transfers, I think that's going to be an issue for all countries, not just the UK, because they all might allow it. Some people would say leakage of data beyond their borders. How do you, we are starting to get to this point where supposedly data protection rules must attach to the data. I think of it as a DRM for data, and then follow data wherever it goes, and they have to be processed in accordance with the EU rules.
You said, I say viral. It's basically the GDPR has viral effect, and we're infecting other countries with our terrible laws. Right. But anyway, so be it.
And also that your final comment about the ICO and that position regarding GDPR applying, I don't know whether that had any influence, but for my PhD and the book I wrote subsequently, that was one of the points that I had covered. It's not original to me, but the whole, I suppose the whole purpose of that was saying, well, if the recipient is subject to the GDPR, then they already have to comply with GDPR rules in relation to that data. So why should it be considered a transfer when the original purpose of the transfer restriction, based on the 1990 and 1992 drafts in the Data Protection Directive, the original purpose was anti-circumvention. So if you're transferring to somebody who has to comply, then there is no circumvention. Obviously, what's happened is that things have moved on, and the transfer restriction is, I feel, being used for a political purpose rather than anti-circumvention. Keep our data so that others can't get it. Keep our data so that we can get it. It's I think it's become more like that.
Possibly. I just think I'm a former computer designing sort of a guy. I'm afraid that my view is that this area is just not logical. It's never been logical.
Totally.
So this is just another area of a breakdown of pure logic, and we just have to live with it, frankly.
Totally. I mean, that was the argument in my PhD and book, that it's not logic, it's politics, and the focus should be on security rather than data location. That's more important.
Very
well,
good.
Talking about political, somebody has sent a slightly cynical comment in. When you said the issues we have with this are political, they have said, is this an instance of vaccine revenge? Now, I think that's a bit going a bit harsh, but as you say, it emphasises the political aspects to this.
Yeah.
Unfortunately, as I had a problem with Zoom earlier, it seemed to keep logging me out for a couple of times, so I missed most of your talk, I'm afraid, Kuan. But are there any chances this might fall down? I didn't hear whether you mentioned that, so I just want to ask the question. Do we, and on what basis might it fall apart, even though they said they want to go ahead?
Well, there's two. I suppose there's two aspects. One, will it get through? And two, even if it does get through, will there be a Schrems 3, for example, challenging it? So, yeah. I mean, whether it'll get through or not, the EDPB's opinion is only advisory. It can't actually stop it. It's really for the council, it's for the member states to vote on it. And politically, I think there is an interest in trade flows and continuing that. So I think there will be a lot of impetus to approving it. Whether it can be challenged, of course, we don't know. It may well be challenged, but it'll take a few years before it happens. And if it does, as I mentioned, there is a mechanism in the Trade and Cooperation Agreement for a partnership council between the UK and the EU that can actually amend that agreement, can supplement it, can make recommendations about flows. Of course, that agreement already contains provisions allowing this bridging period, allowing flows. So they could maybe extend the bridging period, etc. So provide a solution relatively quickly to anything that happens that strikes down the adequacy decision, unlike with the privacy shield where there was no safety net.
The only other question I'm going to ask is pure speculation. Do we think that we will keep in bounds enough for in 4 years' time? We'll still keep that decision.
I mean, who knows?
Who knows? Yeah,
you can't tell, can you?
No. Yeah, I think a more realistic risk is that we will see a Schrems type challenge.
Yeah.
Because there's quite a lot of weight of cases from Privacy International and others showing that distinction on those surveillance sections, the ones you mentioned that are particularly thick in this document. And so, although I take your point, Kuan, that there's powers to amend it if there is a challenge, that won't stop companies attracting liability for the period they relied upon it if the court successfully shows that it was in fact inadequate for its purpose. So there's still a decision to be made by companies about whether to rely upon it if they suspect there's going to be this third-party legal challenge.
Yes, but it's not retrospective. If you relied on an adequacy decision and then it's invalidated, you can't be done for the time that you invalidated it before. Sorry, that you relied on it before it was invalidated. Going forward, yes, if it does get invalidated by the court, then you have to put something else in place. And that's why so many people have been scrambling with model clauses after Schrems 2. But I don't think you can be done for relying on it before it was invalidated. I mean, at the moment, this is the most watertight, foolproof way to transfer data at the moment, which is to rely on an adequacy decision, because unless and until it's invalidated by the court, you have to be able to rely on it completely. it's SCCs and BCRs that you need supplemental terms and, transfer impact assessments, which personally I think shouldn't be necessary if you can use good technical measures to protect the personal data, whoever's got it, wherever it is.
Now, interestingly, in the small print, as you'll know, of the GDPR, if you have adequacy in place, you are not actually permitted to use SCCs or BCRs, so they're not available to you. So actually, all these contracts that people have been putting in place between the UK, Europe to the UK, all completely useless once this thing gets approved.
Well, you could, yeah. A lot of contracts are being drafted to say they only apply until something else better, like an adequacy decision, and some of those contracts do fall away. So,
well, it depends on the drafting. Very good. Anyway, fascinating, and welcome that it's arrived.
Oh, absolutely. Well, we will see, but hopefully it'll take less than the 4 months, because if we go by Japan, which took 4 months, then we'll be out of time. So hopefully it'll be 3.5.
I think that's great on that topic. Obviously, you've done a great job on getting to grips with it very, very quickly, Kuan, because it only came out about lunchtime, didn't it? So it's good to be breaking news on TN Tech. Obviously, one of the things that we've all got to deal with now is data breaches, and as a result of data breaches, there's been litigation, and group litigation is coming to the fore. And I know, Ashley, you spotted a recent judgment that highlighted a few issues about how group litigation is going ahead.
Well, I'm kind of with the logical, and so in that you need to think about where is your real risk in this space. As a business, is your real risk from the regulator and fines and sanctions, or is your real risk from counterparties who might sue you through breach of agreement? Or could you have lots of unhappy users and sue you under one of these so-called class actions? And I think that's an important decision and evaluation that you need to make. And actually, it's not just a business viewpoint. As a consumer, how am my rights best defended? If I write to the ICO with a complaint, do I have any reasonable expectation the ICO will deal with that properly and I'll get redress? Or do I need to resort to courts somehow and just get some sort of recovery from the damage or loss that I've suffered? And so I actually think that, the ICO does a great job with the resources it's got, but it's underpowered compared to what needs to be done. And so the role of litigation in the courts is extremely important. And in the UK and in data protection, the situation is kind of complicated and developing just as we speak. There are essentially two sorts of ways of bringing claims in the UK, either by representative action or something called a group litigation order. The group litigation order is opt-in, so you've got to get people to sign up. Representative action, you pick a person who's representative of a whole class, and those guys don't need to opt in. And so, as you may have talked about before, it's the Lloyd versus Google and other cases. Now, in the GDPR, you'll know that there's a section in Article 80, and it's replicated in 189 of the Data Protection Act, which will allow for not-for-profits to bring actions on behalf of their members or on behalf of society. And this seems like a good idea, but in a recent consultation just completed, the government has decided not to introduce domestic legislation to push those terms into UK law. And this is at odds with, for example, the law in the Netherlands, where they already have a well-functioning regime to allow the GDPR to work as written and correctly in that way. So with that GDPR bit out of the way, we're now back to those two methods under English law, representative actions or GLOs. And so for representative actions, we'll see what Lloyd and Google says in hopefully a couple of months. That'll be fascinating. But for GLOs, there's a really good new development, which is this British Airways case. And it's a GLO in relation to the data breach that's quite famously reported in 2018. And one of the interesting things about it is that it talks about two areas. One is what the cut-off date should be to allow people to join. When is the deadline? And secondly is if you advertise, if you're the law firm or the group bringing the claim and you advertise on TV or similar, can you recover those costs as part of your claim? And that's important because actually the financing of it is actually an important part to get these cases going. You wouldn't be able to get them going, really, in my view, without funding. Now, on the deadline, it's really interesting to see that despite the promotion they've had on this case, they've only had 5% of the possible affected individuals in this case actually sign in or email in saying, yeah, I want to be included in this claim. And even in the optimistic suggestions of the lawyers in the case, they say, oh, maybe it might be 8% in a couple of months. Well, that doesn't seem like you've really got the attention of people who are concerned about the loss of credit cards or other data as part of the breach. So I don't know whether that is an important indicator to how successful those sorts of claims might be in the future, or whether it's an indication on it's being badly promoted, or whether actually no one really cared about the BA data breach in real life, and maybe a different breach would have different numbers. So that's good to watch.
But there's potential. Am I right? I think there's a potential market, if you call it that, of 500,000 people, isn't it?
Yeah, exactly. Now let's just think about the economics. So there's kind of a rule of thumb that you might claim, I don't know, €500 or £500 per person as distress, meaning the loss of control of your data and so on and so forth. So you've got to multiply your 500,000 by that £500. And then, of course, if you're the prevailing party, you get to recover your costs and legal costs as well. And you'd want to put in that marketing cost, the TV adverts. And I think they'd spent 450 or so £1,000 on it so far, and have planned another 500,000 or more to spend. So actually, there's quite a big investment cost in this claim building. And so a really important decision for people trying to understand the risks of whether these sorts of claims, the GLO claims, are going to get built and either A, attack your business if you're on that side of the equation, or properly represent your rights if you're on the consumer side.
And what was the decision on the cost side of things? Because it's this £440,000. Did they get that?
They're not getting it. They said, I'm going to misreport this by saying, you lawyers, you can get paid for your hourly rate. You don't need to claim this on top.
Overheads, I think they
it's part of your hourly. I mean, you're so outrageously expensive anyway. Just suck it up and pay for it. That's not exactly what they said in the judgment, just to be clear. But one wonders whether we will see more interesting ways of advertising these things to build the claims, and one view, give people access to justice, or at least access to compensation. Because why not? If you're damaged by something because a large corporate's done something wrong, and if the ICO is not replying to you, why shouldn't you be entitled to a couple of £100 back? I mean, that just seems to be fair.
Well, that's what sort of struck me as somebody who has done marketing in the past, is saying they've spent £440,000 on getting people to have free money. I mean, I'm paraphrasing here as well now. That doesn't sound like a very good advertising campaign. But how do I?
Yeah, something's not right here. Something is not right. Something's not right. I agree with that.
Excellent. Okay, so we'll move on to the next topic that we're going to talk about today, which we touched on briefly last week, which was the EDPS's opinion on Digital Services Act. And I know, Kuan, you've got a couple of observations you want to make about the direction that act is going and that opinion.
Yes, I mean, content moderation. I guess I have a bit of a story to share. I think that at the moment, and I'm not sure it's going to help to perpetuate that, the law is very much in favor of those who want to try and take things down. It's quite hard to challenge takedown. So if you want to try and get platforms to moderate and give them some exemption from liability, probably a lot more needs to be done on that front, because if somebody complains and they've ticked all the boxes, filled in the right form, put all the info they're supposed to, then the platform is supposed to be aware and therefore loses its immunity. Even though the platform is supposed to then hear out the person who's put the content up, give them a chance to put their view, etc., etc. It seems that it is very much in favor of those who want to take things down, even if it's not really illegal. And because I do bits of JavaScript to help me in my day-to-day life. A few years back, I actually wrote myself a little form that returns the search results from a particular free legal website in the order I wanted, which was reverse chronological. At that time, it didn't do reverse chronological. I don't trust relevance unless I decide whether it's relevant. So I wanted to return it in reverse chronological order. And I just put that form up on an old blog I used to have, and they got it taken down. And I'm not quite sure what exactly the breach was, and I didn't bother contesting it because I've still got the form. And actually, since then, they have given a reverse chronological option. So, in terms of content moderation, I think it's still a bit biased in favor of those who want to take things down. Obviously, there are other aspects to the opinion, like online targeted advertising. And I know, Ashley, you have particular views about that. It is quite a controversial subject. And the EDPS has said it wants it phased out. And that's quite an extreme view. I mean, for me, I've only ever, and I confess I did buy something from a Gmail ad that I saw for some music equipment. Not what you see behind me, but something else. But often the ads I see are for things I've just bought already, so I don't want to buy it again. So to me, it's really ultimately it's more a balancing act between people wanting free content, but then how much personal data do you have to give in exchange for it? And I know you probably discussed the e-privacy regulation last week.
Very briefly, yeah.
But I noticed the council version had an interesting recital saying if it's necessary to provide a service, then you can do it without consent. For example, for journalism, if you have publications which are wholly or mainly financed by advertising, then they should be able to do that as long as they've given the end user information about the purposes of cookies and they've accepted it. So that's quite interesting, sort of going back a little bit. But granted, those ads could be contextual rather than behavioral based.
Yeah.
But I think this is going to sort of seesaw back and forth a bit until it settles in the middle. And I guess the final comment I had on the EDPS opinion was about recommender systems. And I'd like to say that I want to be profiled, actually. They've said, oh, you base recommender systems on profiling. But, I probably watch too much TV. And a company that I no longer subscribe to keeps sending me emails, even when I was subscribed to them, saying, wouldn't you like to see these great movies? I've seen them on your service. So you don't have to say, I would like you to keep track of what I've seen and then suggest good stuff that I'd like to see based on what I've seen. I like that. I'm quite happy for you to do that. But don't keep asking me to see stuff I've already seen, or stuff that, like, for example, these reality type shows or whatever. I'm never going to, I don't watch these sort of Kardashian type things. I've never once, if you track my behavior, I've never once watched any of that. So why do you send me stuff about that? And I would much rather, I'd love to see relevant information about movies and shows I want to see based on, I'm 99% of my watching is crime drama, for example. Send me more of that, so I guess, I think there are uses for recommender systems. I find, Amazon Prime is probably the best in terms of people who've watched this have also watched that. And actually, I find that quite helpful. I mean, the navigation, the user interface is a bit painful trying to go back and forth, but, I actually find that more useful than some of the random things I've seen from other services, including, as I say, things I haven't seen.
Sorry, Kuan. Actually, did you have anything to to add to
Well,
that?
I think that, and just let me say at the outset, this is a shared computer with my wife, so that's the reason why I always get adverts for Christian Louboutin high-heeled shoes on all the web pages and no other. It's crazy. The European Commission has been in a vendetta against behavioural advertising for many years, and I was involved in some of the lobbying involved in that some years ago. To be honest, the ad industry hasn't helped itself either. So it's not blameless. I mean, it could easily have restructured itself in a better way to better comply with the law. And underpinning this is really a change in public perception. If you asked people 10 years ago to explain to them, oh, look, people kind of know which pages you're going to, and they're delivering adverts based upon that. They think, oh, that's a bit weird. I'm being creeped out by that. They're following me. But if you ask people today, I think the sentiment has changed, and there's not that sensitivity for that sort of activity, particularly when you compare it to some really egregious other activity that's happening in the online space to do with tracking and profiling. So it's an unfortunate battle between the regulators. This rather outdated e-privacy measures caught in the middle of it. That original provision has been misused throughout time for consent for cookies. It's just a mess. Anyway, hopefully there'll be a navigation out of the mess. That the e-privacy will be amended in a helpful fashion, and that users get better notice of what's happening to their data. That's really all they want, and some better rights to enforce against it. If people could do a better job there, then I think it would be well on the way for giving a more satisfactory service all round. As to that basic premise, adding in default by design and default meaning off, turn everything off by default, it's a nonsense. It is clear that targeted ads and behavioral ads pay for the internet. And it's just not credible to say, oh, in a stroke, you can't have any form of targeted or behavioral advertising because it generates such a huge amount of money that we would have to find other ways to raise revenue for those services. Maybe people want that. Maybe they want to buy a subscription to use Google search. But let's just see. At the moment, it generates a lot of money, and it is part of the experience that we've all got.
Yeah, I think absolutely. People like free stuff, and it's just finding that middle ground, that middle way. Hopefully we'll get there.
Yeah. We're sort of a little bit over time, but we've still got people listening in. So I'd like to just raise one more thing that we were just going to briefly talk about. And it's slightly related because it's about analytics, and that's how we understand what people are doing. The ICO has released a data analytics toolkit that I know, Kuan, you've had a look at, and just to let our listeners know that it's out there. And what do you think of it?
I think you're still going to need a lawyer. I don't think, and this is not me being partisan. I actually went through it myself when it came out, and I tried to be the most ignorant person possible, saying I don't know anything at all. Tell me stuff, and when it tells you stuff, it's not necessarily stuff that you could understand without a lawyer. It's quite legalistic. It's very much focused on AI, and of course, there's a lot of analytics which is not AI.
Yeah.
So, yeah, I thought it was a bit more of a sort of legal treatise rather than a toolkit, but that's my view. I mean, what do you think, Ashley?
It is the most unhelpful thing known to man, frankly. I mean, just imagine the average user of this. So, say you're a DPO in an organization. I look after the forum, which has got loads of them as members. And these people have tough jobs at the best of times. And they've got to tell their senior boss about this new rules from the ICO. The last thing they want to do is send their boss to a link that he or she has to click the way through and answering questions they don't know the answer to. And for 5 minutes later, have a whole page of stuff they don't want to read. That is not going to improve anyone's life. Just put it in a PDF with a couple of flowcharts. What's wrong with a flowchart? I love flowcharts. It's just got to be straightforward. It's so unhelpful. And it kind of gives the impression that if you do succeed with your misticking of boxes, you've somehow succeeded in some way. And somehow got some stamp of approval or comply with anything. Nothing's further from the truth. They just need to set it out rather clearly. It's not a toolkit. It's not even helpful. You can't go back to it. You can't save your position. You can't contribute to it. It's disaster. Take it away and just write it down.
Much more polite to me. And I have to say, I agree that, this approach of making people go through a million screens answering things, it's not just this one toolkit. They do it with everything else as well.
All over
the entire website.
Yeah.
And this is supposed to help SMEs. And like you, I just think, well, just do one web page. And please allow us to have PDFs, and please provide last updated dates, by the way, for your guidance, which they've stopped doing. But yeah, there are a number of things which could be more helpful to the user. I'm being more polite about.
Yeah, I mean, what do they think is wrong with an SME? That it can't. Its focus of attention is so short, it can't read a full page of text without pressing a tick box or a next button. That is not the problem your average SME has.
Yeah,
it's not helpful.
Yeah,
not helpful.
And in fact, it's more tedious having to keep going next. So I know I can completely. An online tool should not be like that. It's not as helpful as, I've been working on various online tools at my firm for clients, and they're much more user friendly, I have to say, than having to do this. But let's see what happens in future. I mean, this seems to be a strategy they've agreed on because it pervades their website, having this approach.
Yeah. Yeah.
Especially for SMEs.
Yeah.
There used to be, I'm not up on this, Kuan, you may know, but there used to be laws about equality and access of people with disabilities against websites. And the BBC was the only website known to man that ever complied, ever read these laws, and did a very nice job, may I say, in letting people have access. This cannot be compatible with people with needs and who want to have access. We should maybe write to the ISO and get to take it down on that basis.
You could do that. You could send a freedom of information request to the ICO saying, "What are you doing on the e-accessibility front?"
Exactly. It's just a nonsense.
Okay, well, I think we've overrun our time a bit. Somebody did make a comment relating to paying for Google services, saying, he'd like to see be given the option to pay for a Google service.
Okay.
But
well,
how many other people?
I'll tell Google next time I speak to them that they've got one customer, so that's good.
Be out there? They can test it. They've got a big enough market to test it, haven't they? Anyway, sorry, I think we'll have to leave it there now, Kuan. I'd just like to thank you both for a really lively conversation. That was terrific, great fun. Apologies that somehow at my end, Zoom seemed to keep rebooting itself. So I caught most of that, but I thought it was a really, really good conversation. If you've enjoyed it and you've found it useful, you could appreciate it, send your appreciation by going to buymeacoffee.com/SCL and contributing there. All the monies that we raise there funnel back to our student initiatives, so it helps out what we're doing at the lower levels. You may also want to check out the previous T&T Tech sessions available on the dedicated page of the website, which is scl.org/T&Tech. You can see it there. I will put up a reading list of the links that we've mentioned today, because I think there's quite a few useful links there. We will put a reading list up of that, so that will be available probably on Monday as well. And it will be available as a podcast there as well. Just to say, next week I'll be joined by Lynn Penfold, Nick Watson and Sue McLean. So I hope you can join us again then for another look at the Tech Law Week. And thank you and goodbye and have a good weekend.
Thanks, David.
Thank you.
Goodbye.
Bye.